It is now my pleasure to turn today's program over to Jeffrey Levine, Director of Government and Regulatory Affairs, NG Resources, and Joe Dalton, Government Affairs Director for NG North America, Inc. Jeffrey, you may begin.
Thank you, Emma, and good morning to everybody. For those of you in the Northeast, I hope you're digging out from the snow and dealing with the cold as well as you can. I'm glad you're joining us today. I'd like to start focusing on New York. We'll spend a few moments talking about New York's clean energy standard, and then we'll move on to some other issues. So in August of 2016, the Commission adopted an aggressive goal of 50% electricity consumed in New York from renewable resources, and the goal was by 2030. And this is part of a bigger goal to reduce greenhouse gas emissions by 40% and by 80% by 2050. There are two components to the clean energy standard. There is a renewable energy standard and a zero emissions credit requirement. Both of these standards are going to be run by the New York State Energy and Research Development Authority. Some people just call it NYSERDA, but not many people know what it actually stands for. Here's a link that just gives you a resource if you want to go to it at another time. So the Clean Energy Standard actually has three tiers. Tier 1 and Tier 2 have to do with renewable energy. The obligation, and this is the big change, shifts from a state centralized procurement, which used to be done by NYSERDA, and it now becomes the obligation of ESCOs and individual utilities to buy RECs. So you used to have a renewable portfolio standard charge on your distribution side of the bill, a wires charge. You used to have an energy efficiency. You used to have a universal service charge called a system benefit charge. You had a lot of charges on the wire side. They're not going to completely disappear because the utility will maintain some obligation because the utility is a load-serving entity for default service load. But now ESCOs will also have to have their own individual charges to customers to meet the obligation of complying with the renewable energy standard. The Tier 1 obligation is for new renewables, and that's the one that falls to ESCOs and utilities serving their load. The compliance year is a calendar year, January to December, and it started in 2017. Tier 2 is for existing renewable resources. You have to imagine that New York has, for years, been a centralized procurement model for renewables, and there are plenty of hydro, wind, and solar, both utility-scale solar and small-scale solar that are already under contract, and the maintenance of those contracts will be collected by the utilities through a wires charge. So I will say this could be a bit confusing as we transition to this new model because customers will continue to see a wires charge for renewables, and then they're also going to see a commodity side of their bill, which comes from the ESCOs or the utilities default service, incorporate renewable energy standard compliance costs. It's a percentage of the load-serving entity's load, and you can fulfill the obligation by buying RECs from NYSERDA, entering into your own bilateral contracts with a renewable generator that complies, which for the most part means in-state, but there are some caveats for out-of-state, or you can pay an alternative compliance payment. So New York is trying to become much like the other states and how they do renewable portfolio standards. One interesting point to take into consideration is that currently New York has 26% of its system powered by renewables. So when we talk about getting to 50% by 2030, we're already at 26%, and that's mostly hydro, wind, and run-of-river dams. So here's just some facts. The REC price was set at $21.16 per megawatt hour. The ACP, which would be a payment in lieu of buying RECs, is $23.28. And the percentages for the next 5 years at least are set off to your side. And you can see that it's 0.035, 1.1, and 2. And the reason these are so small at first is if you're already at 26% today, really you only need to add approximately 4%, and you'll be at 30% by 2020, which is on their path to 50% by 2030. Below is just a quick example of how one load-serving entity, like an ESCO, might actually determine what amount of RECs it needs to purchase. So if it has 1 million megawatt hours of load that it's serving, and it multiplies that by the Tier 1 percentage, it realizes it has to buy 350 RECs in order to be compliant for that calendar year. Tier 3, and I didn't go into Tier 2 because that's really going to be a utility function with those legacy contracts that already exist to maintain them. Tier 3 is something that has never been done before, and New York was the first to do this in the nation, creates a zero emission credit, and it's an obligation to buy as much output as the nuclear facilities in New York can produce. So even though solar and wind and hydro are zero carbon emitters, this zero emission credit is specific to nuclear facilities, and not all nuclear facilities, just 3 in the state of New York. So the 3 are 9 Mile Point, Genet, and Fitzpatrick. All are now owned by the Exelon Corporation, and the ZEC, as it's called, compliance period, is a 12-month period but not a calendar year. It's in April to March, which begins next month. You should know that a group of generators have filed a lawsuit in federal court claiming that this interferes with the federal government's jurisdiction of setting wholesale prices. And their thinking is, if you subsidize 3 generators, those generators, when they bid into the New York ISO market, can bid a very low price because they don't need anything from the market. They're being subsidized. So if they bid 0, they will lower the clearing price of energy, and all the other generators in New York won't be able to economically survive on those lower clearing prices that they would get paid. And this, in effect, is going to set the wholesale market price, which the lawsuit claims is a federal jurisdiction of the Federal Energy Regulatory Commission, or FERC, and not something that can be affected by a state program. That's moving through the courts right now. We'll just have to see how that works out. So load-serving entities will be obligated to purchase the ZECs from NYSERDA. They'll do so based on their portion of the state's load. NYSERDA will offer the nuclear facilities 12-year contracts, and the price that they will pay the generation will be set for 2-year periods. So the first 2-year period, which we're in right now, or we will begin next month, is $17.54 a megawatt hour. And again, that'll be adjusted every 2 years. The way they came up with $17.54 is a bit complicated, but I don't think it's too hard to follow. There's a social cost of carbon that's been computed by national studies that were part of the Clean Power Plan under the Obama administration. There have already been monies that have been collected from consumers based on the Regional Greenhouse Gas Initiative. So you start with the social cost of carbon, you minus what you've already paid into Regional Greenhouse Gas Initiative, and then you also minus any amount that's above expected revenues from the market, and that was set at $39. So if a generator, one of these nukes, is receiving revenue from the market that's above $39, then the price per ZEC will go down. It's a little bit complicated, but that's how they're going to calculate it. But what do customers pay? Customers do not pay $17.54 a megawatt hour. That's what the state is going to pay those 3 generators. And they're going to pay $17.54 per megawatt hour for every megawatt hour that those 3 generators produce. So here's an example of how we calculate the ZEC cost to a customer. So you take the $17.54 times the output of the nukes, and it's a big sum of money, and it's a check written to Exelon for those 3 generators. But then you divide that pool of money by all of the ISO load. And if you see below, you'll see an example. So if the statewide ZECs is estimated to be 27,618,000, and that's based on historical output from those generators, and they set it. And the ZEC price is $17.54. You multiply those two rows by each other, and you come out with a total payment, NYSERDA, to the generator of $484 million and change. The estimate of the ISO load is 154 million megawatt hours. That's what consumers use. So you divide those two rows, and the cost to the consumer, granted this is an estimate, it has things like weather normalization built into it, but the cost to the consumer is approximately $3.13 a megawatt hour. And that's what the customer would look for. Now, there is an estimate built into this because that 27 million megawatt hours of output, which is the statewide ZEC value, is an estimate based on historical values. So after the 12-month period, they're going to look at actual output and true it up. So that'll make this formula change a little bit, and the ultimate cost to consumers change a little bit. But that's a good guesstimate of what customers are going to pay going forward for the next 2-year period until they reset some of these issues like the statewide ZEC value and the NYSERDA ZEC value. This is a 12-year program, so we'll have several of these iterations to figure out. Next is a poll question that's going to be pushed out to you, and I'd like you to consider it. Is it better for the New York ISO to maintain market fundamentals by incorporating a price for carbon emissions in generator energy bids, or have the state subsidize individual generators based on the desired environmental attributes? Just about 8 seconds left. Okay, thanks for your responses. So what does the New York ISO do when the state subsidizes 3 large generation units and the New York ISO has to protect its market design? Can the cost of carbon emissions be reflected in the energy market? Well, the New York ISO has started an initiative to address that called Integrating Public Policy. And the idea would be that each generator, you've got nuclear generators, natural gas generators, coal generators, oil, all different kinds of generators, would have their specific carbon emission rate calculated. And then they would multiply that by a carbon price, and they would add that to the generator's energy bid. And that's why it's called the carbon energy bid adder. This is all hypothetical, and this is just something that's a thought piece, but it is being discussed right now within the New York ISO. So a generator unit's emission rate would be reset periodically to allow for improvements. Non-emitters would be paid the full clearing price, but carbon emitters would have that carbon adder clawed back. Let me walk through an example to try and make this clearer. So these are just hypothetical numbers. I've made them up. There's no connection to reality. And we have 3 generators in our situation: a nuclear generator, a natural gas generator, and a coal generator. And the generator's energy bid under normal conditions would be $20 a megawatt hour, $30 a megawatt hour, and $40 a megawatt hour, respectively. The adder for this carbon emissions would be, and again, these are just guesstimates, 0 for the nuclear, because it doesn't emit any carbon emissions, $10 for natural gas, and higher for coal, because coal is a more carbon-intensive fuel source. So then you add those two, and the total generator energy bids to the New York ISO market are now $20 a megawatt hour, $40 a megawatt hour, and $60 a megawatt hour. The clearing price in this hypothetical, I just made it up, happens to be $40 a megawatt hour. So already we can see that the coal unit will not clear. It will not be paid anything because it's too expensive. And that's part of the market incentive behind this construct, is that the dirtier units will be forced to bid higher and potentially bid themselves out of clearing and getting anything. And eventually that's an economic signal for the dirtier units to either retrofit and clean up and therefore have their carbon adder based on their carbon emission intensity reduced, or go out of business. So here we have a clearing price of $40. the nuclear plant and the natural gas plant clear, what price is paid to the generator? The nuclear will get all of those $40. The natural gas unit would only get $30, and the coal unit would get 0 because it didn't clear. What do we do with the money that we didn't pay the natural gas unit, that $10 a megawatt hour? Right now, conceptually, the idea is to refund it to load. So it's an interesting concept. It's one that's out there. There are other markets that have different design fundamentals that Joe will speak about later that have different approaches to this idea. None of these have been implemented yet. And before they are implemented, they would have to be filed at the Federal Energy Regulatory Commission, which is going through severe changes under the new administration. So we don't know the appetite of the Federal Energy Regulatory Commission to support these kind of carbon constraint pricing models. So there's a lot to be determined, and in the meantime, the state has filled that space by moving through its subsidies for these nuclear generation units. Would the carbon adder replace the Regional Greenhouse Gas Initiative? This is a multi-state credit program that is designed to put a cost of carbon based on an auction and have all carbon emitting resources within the participating states buy those RGGI credits. So currently, carbon emitting generators buy the RGGI credits and then they incorporate those costs into their energy bids, kind of like a cost of doing business. I've got to buy fuel, that cost goes into my bid. I've got to buy RGGI credits, that cost goes into my bid. And that raises their energy bid. But if you couple RGGI with this carbon adder idea that I just talked about the New York ISO proposing, then you have these generators losing the recovery value in their energy clearing price because it would be clawed back. So if they're incorporating the cost of certain greenhouse gas compliance reduction costs into their energy bids, but now that's being clawed back, then the generators are going to be at a loss and they're going to complain about that. So I think you're going to see the community of generators push for one or the other, but not both. So there's no real easy answer. I can tell you a lot of this is being driven by the governor himself, and I don't think Governor Cuomo is likely to withdraw from the multi-state RGGI initiative. I do also believe that the governor will oppose the New York ISO idea because it would replace the recent state subsidies and the ZEC purchase obligations. So you have to consider the political as well. You've got these large employers that pay lots of taxes or payments in lieu of taxes, and the governor didn't want these businesses to go out of business. Well, he came up with a subsidy for them. Anything that's going to try to undermine that, I bet he will oppose. And just to give you a sense of costs, the RGGI auctions have historically cleared very low. The most recent one in December of 2016 cleared at $3 per ton of carbon, a much lower price than was used in formulating the ZEC payment. So, you know, one is cheap, one is a richer payout to the nukes. I don't think you'll do both, and we'll have to see what the New York ISO wants. Let's move over to the Public Service Commission. Chairwoman Zibelman is leaving effective March 20th, so just next week. She will be heading to Australia to be the chief executive of the Australian ISO. It's called the Australian Energy Market. There are 2 members of the commission left. We already had vacancies, and with hers, we now have 3 out of 5 vacancies. There is no quorum. We don't have a quorum because we have 2 out of 5, but according to state rules, they are still allowed to decide on cases and issue orders as long as it's unanimous, meaning they both have to agree. Commissioner Sayer and Commissioner Berman have typically not agreed, so it'll be very interesting to see what happens. I think there's a struggle to find qualified nominees for the commission. I think everybody at the commission realizes they're doing what the governor asks them to do, and in a highly politicized environment, that can be a challenge. So I want to talk about a few items that are coming out of the Public Service Commission. One you probably have already heard about called Reforming the Energy Vision. In a nutshell, we're talking about trying to incentivize smaller, cleaner, and closer to the customer generation resources. Think advanced meters, distributed generation, energy efficiency, microgrids, batteries, data crunching, etc. I think from what I've heard the Commission say about this over the last several years, we're really talking about a prosumer, a consumer that also is empowered to control their consumption and animated to push megawatts back onto the system. So far, we've only gotten approval for utility demonstration projects, both behind the meter and in front of the meter, both to help consumers and help distribution system needs. Another part of the Reforming the Energy Vision docket will be reforming utility tariffs and the compensation mechanisms that utilities generate, because if all of this reduces consumption and utilities are paid for the volume that flows, it could really hurt their earnings. So new mechanisms for the utility to earn are being considered. Just recently, as in last week, the Commission approved a new compensation structure for distributed energy resources based on what they call the value stack, where you have more than one resource stacked upon itself. Think of solar combined with battery storage. This would add benefits to what is paid to consumers and eventually replace net metering, which today is at a full retail rate. But as we stand today, we're still basing payment to consumers with behind-the-meter generation on net energy metering rates, but eventually we're going to shift away from that. And eventually the New York ISO is going to hopefully kind of integrate smaller resources better, test technologies, better understand the physical capabilities. They understand generation very well, large-scale, centralized generation, but they don't necessarily understand how behind-the-meter smaller stuff can work. So the New York ISO is going to do a few pilot projects and then put out a project RFP for the end of this year, where they hope to get certain proposals that they can test and learn from. Another big issue in New York is related to FERC Order 1000. Basically, transmission used to be built when you had an economic constraint or a reliability need. Now the FERC Order 1000 said we're going to allow transmission to be built for public policy goals. So let's say a state wanted to have more renewables. And in New York, the renewables are upstate, but the load is downstate. So we need more generation to move the upstate renewables to market. Well, now we can go ahead with a transmission solution based on that. So we have several in the pipeline, and they're going to be expensive, and they're going to flow to consumers. So one is called the Transmission Owner Transmission Solutions. It's a series of projects that will be about $2.9 billion when all is said and done, and the cost for 2017 is about $37 million. We do not have a lot of visibility into what that cost will be in out years. We just have to wait and see. Another transmission project that is clearing its way through the ISO and the New York Public Service Commission, awaiting approval, is called the AC Transmission Initiative. That'll be a cost allocation to load in the following way. 75% are allocated to the beneficiaries, and the split is among the ISO zones as I show, and 25% are based to statewide load. So the other big effort that is at the Public Service Commission is the investigation into the retail market. In 2016, the New York Public Service Commission came out with an order called Reset the Market. And what it said is ESCOs can offer two products. Product one is match or beat default service. Product two, at least 30% green, and you can be higher than default service. And that was it. They also soon after came out with another order limiting the low-income customers' participation in the market. There were lawsuits that followed from groups of ESCOs, and the courts, interestingly, agreed with the ESCOs. And the courts said, while we believe the Commission has the authority to do what they're doing, we think the Commission failed to follow procedure with proper notification, building a record, soliciting feedback, and then coming back with an informed decision. So in response to all that, the Commission has opened up an investigation into ESCO standards, meaning what criteria should we measure in ESCO in order for them to be licensed and operating, consumer protections, product offerings, should we allow for variable price, should we only have fixed price, and price transparency. How should we benchmark the prices that are out there so customers know if an ESCO is offering a certain price, is that expensive or is that a good deal? So this last investigation is really an attempt to create a record and follow procedure. It's going to take place over the next 6 months. It's already begun. Comments are due in May. Hearings will be in June. Orders will come out in the fall. And there's a healthy suspicion that this is an attempt to go right back to what they wanted to do before in 2016, which is limit the products and exclude low-income customers from participating in the market, but follow all the proper procedures so that if any ESCO does sue, that the court will defer to the Commission and reject the ESCO lawsuit. I do want to bring up a second poll question we have for you today. Will the departure of Public Service Commission Chairwoman Zibelman impact the conclusion of the Reforming the Energy Vision initiative? She's been a primary driver of it. It was her personal project, and it's been going on for 2.5 years. There's a lot to be done for it to conclude, and she's departing next week. 5 more seconds left to submit your response. Thank you for that. So, Indian Point retirement. Governor Cuomo is driving this. He's always wanted to shut it down. He claims that any reliability threats from losing 2 gigawatts of generation that supplies 25% of New York City's supply will be made up for in efficiencies and demand reductions, transmission upgrades, new facilities, mothballed units coming back online. There's a healthy bit of skepticism about that. Under the agreement with Indian Point, the first unit would retire in 2020, the second unit in 2021, with possible extensions to 2024 and 2025 if needed. So I want to talk at the end about what the future of the New York ISO landscape is going to look like. So we've got some proposed new natural gas combined cycle units. Cricket Valley and Competitive Power Ventures have 2 there, and they're supposed to enter the market in 2018 and 2019. We have new transmission in Champlain Hudson Power Express, which is basically Montreal to Queens, Hydro-Quebec, 1,000 megawatts, 2022, 2023 timeframe. And then we have these AC transmission projects, which are going to be for that FERC Order 1000 I talked about earlier. And we then have the retiring generation of Entergy's Indian Point, which is 2 gigawatts. What's interesting is how is this going to affect the market? Well, a lot of people think that the future will be same as today. You've got 1,900 megawatts of transmission capability being added. You have 2 gigawatts of generation going away. You've got the generation that was Cricket Valley and CPV also being added. And I think the bottom line in terms of how you foresee the future is that the timing will matter. If the transmission projects start early, that'll bring more megawatts to market, put downward pressure on reliability requirements, put downward pressure on energy prices. Sounds like a good thing, but there's going to be a likely reaction that you'll have more retirements of existing facilities in the New York City area, which will then put upward pressure. If Entergy shuts down before the transmission lines are ready, well, then you're going to have upward pressure on reliability requirements and on energy clearing prices. So that concludes our New York regulatory affairs update. I'm now going to turn it over to my colleague Joe Dalton, who will update you on New England items.
Thank you, Jeffrey, very much. And just a reminder for our audience, questions will be answered following my presentation. If you could just denote whether it's a question related to New York or New England as you submit them, that would be great. The presentations will be made available as well as the results of the poll questions. So thank you, and the questions are coming in, and we look forward to getting to them. So what I thought I would do is just a quick round the horn for New England legislative highlights, and these are really highlights, just a couple of the top pieces of legislation we're expecting to see coming out of these legislatures. some of the regulatory proceedings in Massachusetts around solar and storage, the integrating markets and public policy process, and some of the recent court decisions on infrastructure that are impacting all of this. And I think, the whole region of the Northeast, take New England and New York, are considering a number of these issues. The issues will rhyme throughout the regions, and there's some evidence of that with respect to the specific legislative proposals. So we'll start with Connecticut. The big news out of Connecticut is the consideration of Bill SB 106, and the fancy title is an act concerning the diversity of baseload energy supplies in the state and achieving Connecticut's greenhouse gas emissions mandated levels. What does that mean? Connecticut is looking to preserve the Dominion nuclear power plant in state. They're concerned for a couple of reasons. One is the huge jobs and tax creator for the state, and the other is that the region and the state's emissions reduction requirements can't be met without it. This is problematic from a competitive wholesale market perspective, because what the bill will do is allow the direct contracting for the output of this unit with individual utilities. It is married with this HB 7247, an act establishing a carbon price for fossil fuels sold in Connecticut, which would then add on to the burden of the first bill by instituting a carbon price that would be required to be paid by every electricity resource, retail electricity supplier, including the utilities, in that state as well. So this is going to consume a lot of the legislative oxygen in the state of Connecticut. It was considered at the end of the legislative session last year and passed, and it failed to pass at the very end, which is why it's come up. It is coming up in the context of this larger regional conversation on carbon that Jeffrey alluded to is happening in New York, as well as a number of other state initiatives and the regional New England Power Pool process, which we will cover in a moment. In the state of Maine, a little less active. Maine has had a longstanding concern about net metering credits, and that's reflected in the fact that how they're going to dispose of or create a solar policy in that state. There are a dozen solar bills that are under consideration right now, and so it's unclear whether those will be pulled together into one product. This is a long-running dispute between the legislature and the governor in the state of Maine, and so we're going to see something on solar in all likelihood, although what the final form is, how many pieces of these 12 bills come together is yet to be determined. And the legislative bill 260, which is an act to create the Maine Energy Office. This would consolidate a lot of the energy policymaking infrastructure in the state and would allow them to set from their perspective, a clearer course on a number of these things. In the Commonwealth of Massachusetts, the Commonwealth has an 18-month legislative session. So they began this year. The session will actually run through the end of July next year. What that means is that there are a lot of bills that have been introduced, but there is also a fair amount of legislative change that's taking place right now. In the Joint Committee on Telecommunications, Utilities, and Energy, longtime Chairman Ben Downing stepped down. He actually retired from the Senate last year, and he had become quite expert in many of these legislative issues dealing with the jurisdiction of the committee. He has been replaced by Senator Michael Barrett of Lexington. So he is getting up to speed. He is conducting meetings with his committee members, as well as reaching out to the House Chair, Tom Golden, to set a course. What we'll get to in a couple of slides, however, is that much of what's happening in energy has already been, the die has been cast in last year's legislation, and a couple of court cases that really has shifted kind of the energy policy making over to the administration, the Department of Energy Resources, the Department of Public Utilities, the Department of Environmental Protection. And so dozens of bills have been introduced, but we won't see much come out of that committee in all likelihood until the later half of this year, perhaps early next year. In New Hampshire, there is really one major energy piece of legislation. There are a number of bills that have been introduced, but the one that has most folks quite interested is the SB 128, which is relative to the policy goal of electric utility restructuring. So in New Hampshire, they have a newly elected governor, Chris Sununu, who has made cost of energy one of his priority issues, and through this legislation seeks to enable the Public Utility Commission in New Hampshire to approve electric distribution company contracts where the purpose would be to moderate the fluctuation in or the volatility in the energy market. This is widely seen to be a vehicle to permit the New Hampshire utilities to contract for the Northern Pass project, as well as initially it was seen as a vehicle perhaps to permit contracting for some natural gas transmission, although subsequent amendments have made that less likely. That legislation is under active consideration in the Senate and will be voted on in the next couple of weeks. In Rhode Island, the H 5369 relating to health and safety, Energize Rhode Island. This is a clean energy investment, a carbon pricing bill, and is before the legislature there. And in Vermont, there are 37 bills on energy and climate that have been introduced in committee. So we won't know for a little bit of time as to what surfaces and is most likely to get attention. Moving on to a couple of the Massachusetts initiatives that have gained a lot of attention. Under the previous administration of Deval Patrick, the Commonwealth embarked on a very aggressive solar development. What started as a program to encourage the development of 250 megawatts of solar through a solar renewable energy credit blossomed to first 400, then 1,200, then 1,600. And the latest iteration of a solar incentive program has been picked up by the Baker administration, and they've coined it the SMART program, the Solar Massachusetts Renewable Target. This will be essentially the phase 3 solar incentive. It differs from the SREC program in a couple of significant ways. The first is that it will be a declining block auction as opposed to direct SRECs. They're shifting the burden for the procurement of these resources away from competitive electricity suppliers and over to the electric distribution companies. The base compensation rates will be the same across the entire state. That's a change where different regions had different rates over the course of the previous programs. And then these rates will be married up with fixed contract terms of 10 years for smaller projects and 20 for larger projects. There are going to be specific adders that will be available to developers where location, pairing their projects with storage, having a benefit to low-income customers, being a community shared solar project, all of these will result in increased incentive for the developers. The maximum size for these projects is 5 megawatts, and the implementation is going to require both Department of Energy Resources and Department of Public Utility action. And the hope for implementation date is January of 2018. There is still a number of details that are being worked out amongst the solar industry stakeholders. Moving on, we have our third poll question for you. And this question is, will the Trump administration approach to environmental regulation change the way the New England states treat emissions reduction policies? And 30 seconds for your response. And as you are answering that, we will move on to the Massachusetts Energy Storage Initiative. This initiative was launched by Governor Charlie Baker in 2015 with the goal of attracting storage companies, accelerating commercial applications of storage in the Commonwealth, expanding access to markets, and developing a framework to support all of these goals. There was a $10 million commitment to conduct a study, perform market analysis, and fund demonstration projects. So DOER, the Department of Energy Resources, partnered with the Massachusetts Clean Energy Center on a comprehensive storage report that was released late last year, called State of Charge, where they laid out a series of objectives to basically encourage the development of market products in the Commonwealth. 8 different demonstration project areas were cited as providing great opportunities. There was a particular focus on reducing the needle peaking of the New England energy usage, and that's a proposal that's still in development. There was a legislative mandate for the department to determine whether or not to set a storage target and then to determine how big it should be. So the department, through an extensive stakeholder process, has determined that they do want to set a target. The question of how big was the subject of significant stakeholder input in the form of comment that was filed with the department. Comments were received by January 27th. They're currently under review, and they expect to issue a determination about what the size of the market is, what that should look like in the not too distant future in Massachusetts. Moving on to the integrating markets and public policy process. Similar to what's happening in New York, this process was commenced in August of 2016. The New England states, the energy policymakers of the various New England states, in coordination with the Independent System Operator of New England and the New England Power Pool, which is the association of all the wholesale market participants, began to have the conversation following what was really following passage of the Massachusetts legislation to procure significant quantities of renewable large-scale hydro projects and offshore wind projects. So because those numbers, 1,600 and 1,200 megawatts respectively, 12 and 16, excuse me, respectively, such a large chunk of out-of-market contracting for resources, there was a lot of concern within the region's both policymakers and stakeholders about how to reconcile policies like that with a fully functioning competitive wholesale market. As a consequence, they began this process to determine whether state policy initiatives largely designed to reduce or eliminate carbon could be integrated into the wholesale market construct. They started holding monthly meetings, more or less monthly meetings, back in August, with stakeholders working through projects to price carbon directly was kind of one train of thought, versus creating a forward clean energy market. So figuring out a way to, in a complementary way to the existing forward capacity market, to price clean energy attributes. The meetings were suspended just last month to provide ISO New England with time to identify a conceptual market approach that could be implemented in the near term. The ISO is seeking to develop a market design that could accommodate state-supported capacity resources while appropriately pricing other resources in the FCM without adversely affecting regional reliability. And then the states and stakeholders are in the process of reviewing and negotiating these proposals. This is significant because if you couple this with the process in New York and consideration of similar policy initiatives in the Mid-Atlantic, the PJM region, you'll note that there's so much churn on these issues. There's so much, there are these ZRECs and these legislative proposals to assist the nuclear generating facilities in these regions. That FERC ultimately has decided that they need to step in, even though they're at less than full capacity. They've stepped in and scheduled a technical conference to really dig into these issues for May 1st and 2nd in Washington, D.C. Commissioner LaFleur, now acting Chairman LaFleur, said as recently as December that really the region, and by extension, she was speaking in New England, but by extension I think in New York and PJM, have really, three choices. They can get together on these issues. The stakeholders can come together on a solution for integrating markets and public policy. They can litigate it, which is going to take a lot of time and money, or they can move to kind of reintegration of the markets, re-regulation of the markets. Her strong preference was that the region would move in the direction of coming together. So I think that the calling of the technical conference is designed in part to facilitate some movement in that area. Final topic, and then we'll move to questions, is recent court and public utility decisions impacting the market, and specifically in this case, it's infrastructure development. So in Massachusetts last year, the Supreme Judicial Court ruled in a docket where the Public Utility Commission, the DPU in Massachusetts, had authorized the electric distribution companies in the Commonwealth to contract for natural gas capacity. That decision was challenged at the Supreme Judicial Court, and the court ruled that the DPU did not have the authority to review and approve those EDC contracts for natural gas pipeline capacity. This was significant because any of you following the development of these issues, the market has not, market participants have not stood up to support through direct investment additional pipeline capacity into New England. So there was a notion that perhaps the electric distribution companies could, in a kind of innovative way, but unprecedented way, charge their electric ratepayers for this additional capacity. So that was rejected by the Supreme Judicial Court. It is that we may see a legislative proposal in Massachusetts on that. That's not clear at this point. Similarly, in New Hampshire, the Public Utility Commission had a ruling on essentially the exact same issue and decided more or less exactly the same way, although based on the New Hampshire electricity restructuring law as opposed to the Massachusetts law. And they determined that the Restructuring Act precluded them from, them being the PUC, from reviewing and approving these contracts. That case has been appealed to the New Hampshire Supreme Court and will be heard in the coming months. And the final case of significance is there was also a Supreme Judicial Court case in Massachusetts, Kane versus Mass Department of Environmental Protection, where the court essentially found that the Commonwealth had not been meeting its obligations under the Global Warming Solutions Act to enact, they were setting goals as opposed to hard reduction limits on emissions. And this has led to the development of the Department of Environmental Protection's Clean Energy Standard, which is currently also under review. There's a series of stakeholder comments were submitted at the end of February. What they're trying to do is assess each each industry area, so electricity generation, transportation, buildings, with an obligation to reduce emissions. And so that will be a hotly contested regulatory proceeding, and has already been so. That concludes the New England portion. It was kind of a rapid-fire drill going around the horn. Thank you for your time and attention, and I believe we have some questions now that have come into the queue.
Joe, thanks so much. This is Jeffrey Levine again, and I was able to look at some of the questions, and I'd like to read some of them. Some of the questions have been answered directly to those who asked them. I think some of the questions that have bigger issues at play, I'd like to read out loud for everyone's benefit and discuss. So one of the questions was just a very factual one. When I talked about the ZEC pricing, and I'd mentioned how you calculate the ZEC price, I'd mentioned that if the generating units receive more than $39 a megawatt hour from the market, then there would be a kind of recalculation where they lower the ZEC price. And someone said, should that be $39 a ton? So it's a great question, and we've got to always remember that we've got to convert dollars per ton, which is what usually people talk about when they talk about carbon emissions or the social cost of carbon, to dollars per megawatt hour, which is what the market clears at, what generators are paid in, and what consumers are charged by. And so there is a conversion factor that was used in New York. I won't go into the details, but basically you do have to convert dollars per ton to dollars per megawatt hour. I did mean dollars per megawatt hour because I was talking about revenue from the market. There was another New York question about whether the initiative integrating public policy at the New York ISO would be replacing the state's clean energy standard. And the answer I have is that's the wishful thinking of the New York ISO. You've got to imagine that the New York ISO has a job to run a market. Well, what's going to happen if 3 large generators are subsidized by the state? I'd already described that they're going to start changing how they bid, which will kind of artificially suppress clearing prices, which will make it very uneconomic for the rest of the generators in the market, which will make them potentially retire or seek their own subsidies. And before you know it, you could have a slippery slope to a scenario where the state has to consider subsidies for all generation. Well, in a market where there are subsidies for all generation, you don't really have an ISO in the same way. So the New York ISO would like to be the market-based carbon price model for how to deal with this interest in reducing greenhouse gases, and it would like to replace the New York Clean Energy Standard. I just personally don't think the governor or the Public Service Commission would ever support that because the subsidies to the new generators wasn't just about clean air, it was about jobs, it was about taxes, economic development, etc. Someone else asked a question, a separate question, about what the Trump administration's new policy might do to change New York's clean energy standard, because New York's clean energy standard was enacted prior to Trump's election. Well, it's a great question, and I don't have a clear answer, because on one hand, I could picture a conservative government not wanting the federal government to interfere in states' actions. You know, typically conservative leadership likes states' rights. And so here you have the state of New York doing something. And will the federal government want to intervene and come up with a rule? Maybe not. But what the state decided to do is reduce greenhouse gases and put that cost on consumers, which we also know is not part of this administration's agenda or interest. So basically, we'll know the answer when the new FERC gets impaneled. We have 2 commissioners out of 5. 3 have been nominated recently, and we have to wait probably several months for them to go through their confirmation process. And then we'll have to see what this FERC decides to do. I don't believe FERC is going to, on its own initiative, do something about any of these ISO proposals until any ISO proposes it. What that means is the ISO is going to have to say, I file this at FERC, I ask for your guidance, what do you say? And then we'll really have a better insight into that. There was another question about what the refund means. So again, in this proposal, a generator that emits carbon would be told to add a price to make its clearing price, its bid more expensive. And if you think about that, that's going to make clearing prices more expensive. That could lead to higher prices that are paid. Well, no one wants to, ostensibly at least, raise prices. So the idea would be if the clearing price is higher because of a carbon-emitting resources carbon adder, we're not going to pay that generator all that money because the generator would be happy. They're like, great, I'm an emitter of carbon and I get paid more. No. We're going to pay the generator what it was going to bid. We're going to claw back, and we're not going to pay them that extra adder, and we're going to give it to customers. How you give it to customers is a big question. Is it through some kind of uplift that's positive? Is it through a check? It's really unclear and hasn't been determined yet. Someone else asked a question about capacity, transmission, demand charges increasing. Yeah, there's a real chance that a lot of that will go up. By how much, I really couldn't guess. So we all have to wait and see. Someone else asked, will the transmission owner transmission solution that I mentioned, the $2.9 billion over several years, over several projects, but $37 million in 2017, be billed to ESCOs as a separate charge or included in the LBMP? So I want to clarify the question and answer it in a certain way. Forget about how it's charged to ESCOs. I think we should focus on how ESCOs will charge the consumers. And that's just based on how the contract is. Some ESCOs, I can't speak for every one of them, will have it as a pass-through, where you'll see a line item that says, this is what the TOTS bill was in 2017. I don't know what it'll be in 2018. So whatever it ends up being in 2018, I pass that through. Other places might fix it. We know what it is in 2017. I've calculated a fixed charge. I've baked that into my overall commodity price that I'm charging the consumer, and that's how you're going to see it. So it's not so much how TOTS will be charged to the ESCOs. It's not going to affect clearing prices. LBMP is location-based market price. It won't affect New York ISO clearing prices, so it will be separate than that. But I think if you look at how the ESCO charges it to you, that's really just based on the contract. But it will be a known charge. It will be separate. It won't be buried in the New York ISO clearing price, but it could be included in an ESCO charge or passed through as a line item. And then one question that just came in on New York, and then I'll turn it over to Joe for some of the New England ones. What is the per megawatt hour impact on a customer bill? We think, and that's the example I gave earlier about what a customer pays for carbon. Please don't confuse that the $17.54 per megawatt hour is a payment to the 3 nukes per megawatt hour for every megawatt hour they produce. A megawatt hour is a ZEC, just like a megawatt hour is a REC. You then have to divide that big pool of money that's paid out by all of the load in the ISO. So you're spreading out that payment across every amount of load. And that's where we got the $3 and change number. As more questions come in, I'll try to address them. I know there's some New England ones, and everyone should know that we're also going to be distributing these answers afterwards to the group.
Thank you, Jeffrey. There was a question in New England regarding whether or not Rhode Island passed a carbon tax contingent on other states passing something similar. Rhode Island is currently reviewing the bill referenced in the presentation, so there is a carbon tax bill under review. Rhode Island did, however, and this relates more to the pipeline infrastructure that was referenced at the end of my section of the presentation, and Rhode Island passed its legislation authorizing its Public Utility Commission to permit electric distribution companies to go out and finance a portion, the Rhode Island portion of the investment into one of those projects, contingent upon other states doing so. Which is why the fact that Massachusetts had its Supreme Judicial Court case and the New Hampshire Public Utility Commission had its case, which is why those cases were significant, because in fact what happened was those states essentially through that process rejected that, and Rhode Island then suspended their activity. Maine did something similar. Maine had passed legislation called the Energy Cost Reduction Act, which was also contingent upon other states acting, and without the other states moving in that direction, there was a reversal on the part of those policymakers.
Joe, I was going to take a question that just came through. It was a good point about how nuclear units are typically bidding very low anyway, so you can't bid lower than zero, and that shouldn't affect the clearing price. While I agree that nuclear units are typically price takers, they can bid higher than zero. The subsidy would make that really unnecessary. But also, you have to think of a market where you have economic entry and economic exit. And so if you have 3 units that had issued retirement notices because they were uneconomic, then that would have been economic exit, which would have had impacts on the reliability needs and purchase requirements, as well as the clearing price of market. So I wasn't just referring to what a nuclear plant would bid based on receiving a state subsidy. I was also talking about how, in general, the state subsidy would result in retention of a unit that I claimed to be uneconomic, and under normal conditions would have exited the market, and those megawatts would not have been included in the supply stack and would have put upward pressure on other units and resulted in higher clearing prices. So I don't really see a lot more questions coming in. We haven't gotten to all of them, but again, we are going to respond to them in writing. Here's one that just came in. Actually, if people will give me a second to read it. If energy efficiency and distributed generation continue, would the state or NYSERDA reduce that ZEC rate as the load pool will decrease? Well, no, not necessarily, to be honest. The load pool decreasing would only result in higher unitized price because you're taking the total amount of dollars paid and you're dividing it by the load. And if the load pool reduces, then the unitized price could go up. Granted, there are going to be sensitivities to consumer costs. There's a chance somebody would tinker with the price to make sure it doesn't go up too much, but I can't imagine them really letting it go down too much either, because remember, this is a bailout for some uneconomic units. One question just came in. I'm going to try my best to answer it, which is, aren't the nukes bidding the directed price based on a fixed price of the subsidy? That's the floor, right? That's not exactly how I understand it. My understanding is a value was determined that would be paid to the nukes. So if you demonstrate a public necessity and you're awarded a contract, which those 3 units were by NYSERDA, it's a 12-year contract from April 1st of 2017 to March 31st of 2029, and you have the 2-year upgrades on what the ZEC price is. You have a formula for how that ZEC price is calculated, social cost of carbon minus what's already been paid through RGGI, and then minus any amount above the forecasted energy and capacity price, which was $39 a megawatt hour. So basically, these generators are being guaranteed a certain amount of money. There's an assumption that they're going to make $39 a megawatt hour from the energy and capacity market. And then there's the difference between that and the social cost of carbon minus what had already been paid to them through RGGI. So I don't see it as a floor that they're directed to bid, but if the person who asked that question wants to reach out to us offline, we can do some research and see if we can better understand that. So it looks like we've trailed off with some of the questions. I hope we've answered a good amount of them, and again, some of the answers will be following up in writing, and we'll share that with folks, as well as sharing a copy of the presentation. Emma, I don't know if you want to close it, but I do want to thank everyone for participating and asking all your great questions.
Thanks to all our participants for joining us today. We hope you found this webcast presentation informative. This concludes our webcast. You may now disconnect. Have a good day.